right, sir, are you Howard Celestine?
Yes, Your Honor.
And Ms. Peraza, will your client waive the formal reading of the indictment in each case?
You will, Your Honor.
Mr. Celestine, in cause number 24 DCCR 0919, you're charged with a third-degree felony offense of manufacturing or delivering a controlled substance from January 10th of 2024. That indictment alleges that you were previously convicted of aggravated sexual assault of a child, a first-degree felony, April 13th of 2009. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
And is that prior offense true, that prior conviction? The one that I read out, the aggravated sexual assault of a child, is that true, that is a prior conviction of yours?
Yes.
Okay. And cause number 24, DCCR 1549, it says count one only, but then it says a 20-year term, so it has to be count one and
That's
two.
right, that was my intent.
If it's
That's
20,
correct.
count one and two.
Yes.
Okay.
Oh,
There's only one prior.
right.
So that's what makes that third degree turn into a
The
second.
second degree. Oh, okay. Sorry.
So pleading on count one would only be to the underlying offense.
Right.
Okay, so in 24 DCCR 1549, you're charged with a second degree felony offense of aggravated assault with a deadly weapon from June 24th of 2024. The indictment alleges that same prior conviction from April 13th of 2009. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And again, is that prior conviction true? And did you enter your plea of guilty in this case freely and voluntarily?
Yes, Judge.
And because you actually did what they've charged you with?
Yes.
So in cause number 24 DCCR 1550, you're charged with a first-degree felony offense of murder from June 24th of 2024, and the state's elected to proceed on that count only. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Freely.
And because you did what they charged you with?
Yes.
In cause number 24 DCCR 1551, you're charged in that case with the state jail felony offense of abandoning or endangering a child from June 24th of 2024. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Freely.
And because you did what they've charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Peraza?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've reached with the district attorney, you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Celestine is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true in the cases that you did freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas in each case.
This is the legal turning point. Once the judge confirms the pleas were entered freely and voluntarily and finds sufficient evidence, the case is effectively over. There's no jury deliberation, no contested sentencing hearing. The agreement's control. The prior felony enhances the punishment range, elevating what would have been lower-degree offenses into far more serious exposure.
And cause number 24 DCCR 0919 finds sufficient evidence to find you guilty, and at this time find you guilty of manufacturing or delivering a controlled substance, find that prior conviction true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 24 DCCR 1549 also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 50 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 24 DCCR 1550 find sufficient evidence to find you guilty, and at this time, or find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder, sentence you in accordance with your agreement to a term of 50 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 24, DCCR 1551, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child, sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I am making an affirmative finding of a deadly weapon in cause number 24, DCCR 1549. I'm handing you in all of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff.
This hearing brought together 4 separate criminal cases into one decisive outcome. In cause number 24 DCCR 0919, the defendant pleaded guilty to manufacturing or delivering a controlled substance, a third-degree felony enhanced by a prior conviction. That prior conviction, aggravated sexual assault of a child from 2009, was admitted as true, increasing the punishment range. Under the plea agreement, the court imposed a 20-year sentence. In cause number 24 DCCR 1549, he pleaded guilty to aggravated assault with a deadly weapon. Because of the same prior felony conviction, the charge was enhanced to a higher degree offense. The court sentenced him to 50 years in the institutional division of the Texas Department of Corrections and made an affirmative deadly weapon finding. That finding carries significant consequences, particularly affecting parole eligibility. In cause number 24 DCCR 1550, he pleaded guilty to first-degree felony murder stemming from the same June 24, 2024 incident. Again, the plea was found to be freely and voluntarily entered, and the court imposed a 50-year sentence pursuant to the agreement. Finally, in cause number 24 DCCR 1551, he pleaded guilty to abandoning or endangering a child, a state jail felony, and received a 2-year state jail sentence. Every plea was confirmed on the record as voluntary. The defendant acknowledged understanding the consequences, including the waiver of appeal and potential immigration ramifications. The court made formal findings of competency and accepted the written plea documents. With that, the judge imposed all agreed sentences. The key legal outcome is concurrency. All sentences run together, not consecutively. That means the controlling term is 50 years. The additional 20-year and 2-year sentences do not extend the total time beyond that maximum term, but they remain part of the judgment record. The deadly weapon finding further impacts how that 50-year term is served, particularly with respect to parole eligibility. What we saw here was the system functioning through negotiation rather than litigation. There was no trial, no cross-examination, no jury weighing evidence. Instead, there was an agreement, likely balancing the strength of the state's evidence against the certainty of a fixed sentence. From a legal standpoint, plea agreements provide finality and efficiency. From a human standpoint, they represent the moment when a defendant formally accepts responsibility and trades the uncertainty of trial for a guaranteed outcome. The judge's final admonishments underscore another lasting consequence: loss of firearm rights under Texas law. That disability follows the judgment and exists independently of the prison term itself. Ultimately, this case illustrates how prior convictions can dramatically alter sentencing exposure, how enhancements elevate punishment ranges, and how concurrency shapes the real-world impact of multiple convictions. 50 years, running together, becomes the defining number. Do you think negotiated plea deals like this serve justice more effectively than taking cases to trial? If you found this breakdown helpful, make sure to like, comment your thoughts below, and subscribe for more in-depth courtroom analysis.